Yeah.
Ladies and gentlemen, we'll make a start now. First of all, good morning and welcome to the Sir Samuel Way building. My name is Nicholas Nikolakis and I've been the coordinator this far, also far for the International Humanitarian Law Group competition being run with the Australian Red Cross at the ALSA conference this week. Before we begin, ALSA and the Red Cross acknowledge the Kaurna people, who are the traditional owners and custodians of the Adelaide Plains. Today we have a truly exciting grand final among two very competitive teams, Team 1 the Prosecution and Team 5 the Defence. They will be mooting before a truly eminent panel today provided by the Red Cross, and they are Petra Ball, Professor Dale Stevens and the Honourable Catherine Granson, ACQC. And I'll give an introduction to all three right now. So Petra Ball is a senior advisor for the Red Cross people in the International Humanitarian Law Program of the Australian Red Cross, and she's been extensively involved in ensuring the success of this year's competition, and together she's done that with her colleagues and valued volunteers. Professor Dale Stevens is a Professor of Law at the University of Adelaide and a captain in the Royal Australian Navy Reserve, and has been awarded the Conspicuous Service Medal. Currently, Professor Stevens leads an international team of international law experts in creating a manual on the laws of warfare in space. This is similar to the Tallinn Manual on cyber warfare and the San Remo Manual on the laws of war at sea. This manual will be known as the WUMA Manual. The Honourable Catherine Granson is a barrister and Queen's Counsel and former judge of the Federal Court of Australia. She's also the former president of the Australian Human Rights Commission. This year, she's been made a companion of the Order of Australia for her service to humanity. Ladies and gentlemen, we have a truly exciting group today, and without further ado, I'll introduce our panel. All stand.
call the matter.
In the matter of the prosecution and Vincent Nev and Normie Gregory.
Thank you. We'll take appearances.
Madam President, Your Excellencies, my name is Emily Fackender, spelled Fackender, and I appear on behalf of the prosecution in this matter, along with my co-counsel Isabel Peart, spelled Peart. I will speak first for 19 minutes, my co-counsel will speak for a further 19 minutes, and we respectfully reserve 2 minutes for rebuttal.
Thank you. Ms. Fackender.
Madam President, Your Excellencies, my name is Mr. Westbury and I appear as counsel for the defendants Norman Gregory and Vincent Nev in this matter. I appear with my co-counsel, Ms. Gallia. I will address the court for 19 minutes. Ms. Gallia will also address the court for 19 minutes, and we reserve 2 minutes for sub rebuttal. May I please?
Thank you, Mr. Westbury. Ms. Fackender.
Madam President, Your Excellencies, I will be dealing with the first charge before the court today, that which relates to Commander Nev. It is a basic rule of international law that attacks must not be directed against civilians. The law limits what a person can legally do in armed conflict to protect civilians from harm. Commander Nev's actions on the 5th of July 2016 showed a complete disregard for the lives of the civilian population, and he must be held accountable. For the International Criminal Court to have jurisdiction over the charges of war crimes before the court today, there must be an international armed conflict. We contend that at all material times between the 22nd of May 2016 and the 30th of August 2016, there was an international armed conflict between Arba and Sorax, as there was a resort to armed force between the two states. It is the prosecution's submission that there is sufficient evidence to establish on substantial grounds to believe that Commander Nev was criminally responsible for ordering, under Article 25(3)(b) of the Rome Statute, the crime of intentionally directing attacks against the civilian population, punishable under Article 8(2)(b) Roman 1 of the Rome Statute. There are 5 elements that Your Excellencies must be satisfied for the court to confirm the charge against Commander Nev. First, that an attack was directed. Second, that the attack took place in the context of and was associated with an international armed conflict. Third, that Commander Nev was aware of this international armed conflict. Fourth, that the object of the attack was a civilian population, as such, not taking direct part in hostilities. And fifth, that Commander Nev intended the civilian population to be the object of the attack. I note that counsel for the defence has conceded the first element at paragraph 1.1 of their written submissions. Further, I note that counsel for the defence has not contended in their written submissions that the attack did not take place in the context of an armed conflict between Arba and Sorax, nor that Commander Nev was unaware of that conflict. Unless Your Excellencies have any questions on these submissions, I will turn to consider the next element, that the object of the attack was a civilian population.
Yes, thank you.
We contend that the object of the attack was a civilian population, as the occupants of the city centre, patients and hospital staff located within Stone main hospital were civilians. The definition of civilians is contained in Article 50, Paragraph 1 of Additional Protocol 1, which we note are pursuant to Paragraph 32 of the agreed facts, both Arba and Sorax were parties to. This definition is a negative definition, and essentially states that a civilian is anyone who is not a member of an armed group or party to the conflict, or an inhabitant of a non-occupied territory who spontaneously takes up arms to resist an invading force. We contend that the occupants of the city centre, patients and hospital staff located within Sandtown's main hospital were not fulfilling any of these roles. The civilians were not taking part in hostilities, not taking direct part in hostilities, as at the commentary to Additional Protocol 1, at paragraph 1944, states that direct participation means acts by which their nature or purpose.
Agent, just on that point, I think the court might concede that particular issue, but the attack was on a building, was it not? In that regard, an office building that, under the facts, it seems was being occupied by soldiers from the other side. So in that regard, could you address us on the status of that particular building?
Your Excellencies, we accept that the office building in question was a military objective within the definition of Article 52, Paragraph 2 of Additional Protocol 1. However, in the circumstances, we contend that the attack that was launched on the 5th of July was an indiscriminate attack, and that in these circumstances, an indiscriminate attack may also be qualified as a direct attack on civilians pursuant to the Martich decision of the ICTY at paragraph 69.
Agent Packard, I have a question as well. There was some preliminary activity in this city, I think on the 22nd of May and then again on the 1st of July. What, if anything, can be gained from what was the outcome of that military activity?
Your Excellency, on our submission, we contend that the activity on the 22nd of May was what triggered an international arms conflict, or was the beginning.
I'm thinking more about the extent of the damage.
The extent
Or
of
what might
damage.
have been learned about the likelihood that if you fired, you would indiscriminately harm innocent people.
Yes, Your Excellency. Madam President. We contend that pursuant to the Godovina decision at paragraph 59, the accuracy of artillery weapons decreases at greater distances from the target, and that there are factors such as the type of weapon and the conditions in the external conditions at the time, including temperature, wind, and other weather factors like this, will affect the accuracy of an artillery weapon. And that even if the artillery weapon was used on the 1st of July with limited damage, that these conditions could reasonably be expected to change in the 4 days to the 5th of July, and that Commander Nev failed to take precautions closer to the date on the 5th of July, and that using the weapon without taking these precautions was an indiscriminate use of the weapon, and as such was an indiscriminate attack in these circumstances.
So, can I just carry on with that line of reasoning? I mean, you've made an assertion about changing weather conditions, but do the facts speak to that?
Your Excellency, we accept that there's ambiguity on the facts, or it's not explicitly stated in the facts that the weather conditions had changed. However, we note that Commander Nev, we contend that when carrying out an attack, a person must take all necessary, or must take precautions before carrying out the attack, and that such precautions include verifying the civilian nature of the attack, verifying whether or not the means or methods used in the circumstances were indiscriminate, and that would result in indiscriminate results in the circumstances, and that failing to do that in this situation, it can be inferred that Commander Nev intended or did not care what objects were struck in the artillery fire on the 5th of July.
There was a warning for civilians, I think, wasn't there? What do you say about that?
Yes, Madam President, we do accept that there was an SMS warning. However, we contend that this SMS warning was not effective in the circumstances as required by Article 57(2)(c) of Additional Protocol 1. On the agreed facts at paragraph 17, we know that the warning was only issued 1.5 hours before the attack commenced. At agreed facts paragraph 12, that it was a densely populated city centre with a main hospital that was treating many of the casualties from the conflict. Further, at agreed facts paragraph 13, that previous artillery attacks had caused craters and debris on the main roads into and out of the city centre, making it difficult for vehicles to use the road. We contend that considering all of these factors, and that a main hospital treating civilian casualties to a conflict could reasonably be expected to have patients potentially in an ICU or using machinery or at various states of mobility, that moving such patients would not be a simple task. It would take planning and special equipment, and that trying to do that in a 1.5-hour time frame is not reasonable, and that Commander Nev, knowing all of these circumstances, could not reasonably have expected that giving a 1.5-hour warning would allow the civilian population to leave the city centre in that time.
So just stating on that point, I noticed in paragraph 17, it says that in what I would believe to be a reasonably populated hospital, only 50 patients were unable to be evacuated in that time frame. And it seems to me to be a rather effective warning if all you have in a city hospital is just 50 patients remaining.
Your Excellency, we accept that there were only 50 patients remaining. However, we contend that in taking the precautions and issuing the warning, we must look to the circumstances that Commander Nev was aware of at the time and not apply a retrospective analysis, and that in the situation that he would have been, or the factors that he would have known, it would not have been reasonable for him to expect that the civilians were able to leave the hospital in that time frame.
I'm wondering if the circumstances were the same on the 1st of July as the 5th of July in terms of the artillery attack. Would that have had bearing on your submission that it was an indiscriminate attack? I think the imagery from the drone strikes from the 1st of July indicated somewhat limited damage to collateral damage beyond the direct hits on the roads.
Yes, Your Excellency, we accept that there was limited damage to the other buildings around the artillery strikes on the roads. However, we contend that in the circumstances, artillery, just finding my reference, Your Excellency. We contend that in the circumstances of an urban conflict, that artillery fire, while we accept that artillery fire is not inherently indiscriminate, that in the circumstances of an urban conflict, as noted by Nathalia Dern in International Committee of the Red Cross review article, that explosive weapons in densely populated areas do tend to have disastrous effects, considering that they have issues distinguishing between civilian and military objectives in light of the fact that in an urban setting, these objectives are much closer together and that the weapons have a range of error that could reasonably be expected to impact civilian and military objects without distinction. We contend that on this evidence, it can be concluded that the artillery fire on the 5th of July was an indiscriminate attack that was intended to, that the object of the attack was intended to be the civilian population.
On what basis do you say that? Is there any direct instruction from Commander Nev to that effect?
That goes to my next submission, Your Excellency. At submission 3 of our written submissions, we contend that Commander Nev bears individual criminal responsibility for the crime, for the direct attack against civilians, as he ordered its commission pursuant to Article 25(3)(b) of the Road Statute. To be found criminally responsible under this section, there are 4 elements that need to be found pursuant to paragraph 63 of the decision of Pre-Trial Chamber 1 in the Moot case before this court. First, that Commander Nev is in a position of authority. Second, that he instructed another person in any form to commit a crime which in fact occurs. Third, that the order had a direct effect on the commission or attempted commission of the crime. Implementation of that order. We contend that Commander Nev was in a position of authority, as at paragraph 8 of the agreed facts, it's stated that the 125th Regiment was under his command, and that at paragraph 12 of the agreed facts, we know that he has previously issued orders to the 125th Regiment that have been followed. Further, through his communication on the 5th of July 2016, Commander Nev ordered the 125th Regiment to direct attacks against the civilian population, which occurred in fact, and the order had a direct effect on the commission of these attacks.
Just on that point, I'm not sure I read in the wording that is outlined in paragraph 15 a statement that says you are to attack civilians. It says we push through to a naval base, establish control, and the 125th has the capacity to destroy buildings, providing cover to hostiles. I mean, there's nothing unremarkable about that in terms of the law of armed conflict. Is there? How do I read an attack on civilians out of that statement?
Your Excellency, we contend that Commander Nev's communication to clear the city centre and not delay did not make any distinction between the civilian objects or the military objectives, and that it could clearly be an instruction to attack the entire city centre without distinction. Further, his statement that the 125th Regiment has the capability to destroy buildings clearly had a direct effect on the commission of the attacks, as this was the weaponry that was employed, and pursuant to Article 12 of the agreed facts, in which Commander Nev has previously directed an order to take immediate action to stop armoured troops establishing a defensive position in the city centre, that at agreed facts paragraph 13, artillery fire was the weaponry used in response to that order, and so it could reasonably be expected in that issuing this order, the 125th Regiment would use the same artillery that they had used previously.
Yeah, I mean, I hear what you're saying, but another reading is that there is a level of ambiguity, but a senior commander saying we have the capability to destroy buildings, providing cover to hostiles, could be read as we have the capability to employ weapons under the law of armed conflict to attack military objectives. I mean, there's ambiguity perhaps in this statement, but I think your reading of that is a pretty stretch. Is there anything more you could add that would enable this court to discern intention out of those relevant intention out of those words?
Your Excellency, we accept that there is some ambiguity in Commander Nev's order. However, we contend that Commander Nev was aware of the civilian population in the town centre, considering that at agreed facts paragraph 12 there were images taken by SORAC's drone of the city centre, which could reasonably be expected to also provide images of the hospital, considering it was right across the road, and that further SORAC's ground forces at paragraph 14 were reporting back to Commander Nev on the movement within the city centre, and that having access to this information and further not taking effective precautions to remove the civilians from the city centre, his intention to direct attacks against the civilians can be inferred, and that in stating you must clear the city centre without further putting to the 125th Regiment what specific military objectives to be attacked, that should be read on our submission, that he did not distinguish between the civilian population and the military objectives, and that he intended them to launch the attack at the entire city centre, including the hospital and the civilian population. On this evidence, we contend, at our submission 3.3, we contend that Commander Nev intended to order the attacks against the civilian population, or was at least aware that attacks against the civilian population would be committed in the ordinary course of events. As I have previously raised, Commander Nev was aware of the circumstances in the city centre at the time, as there were drones relaying images to analysts, and he had forces in the city centre relaying information back to him about the activities in the city centre, and that in issuing an order in where he knew that previous orders had been met with artillery strikes, that he intended the order given to also, he intended that his order would also be met with artillery strikes, and as such was at least aware that artillery strikes will be used in the circumstances.
Agent Hagender, we've taken a lot of your time with questions. If you were to ask me for a short extension, I'd grant it to you.
Thank you, Your
Depends whether
Excellency.
you're close to finishing or not.
Your Excellency, perhaps if I could ask for a 30-second extension, Madam President, if I could ask for a 30-second extension to
You may have a minute, Agent Hagender.
Thank you. On this evidence, Madam President and Your Excellencies, we contend that there are substantial grounds to believe that Commander Nev ordered the 125th Regiment, pursuant to Article 25(3)(b), to commit the crime of intentionally directing attacks against the civilian population, pursuant to Article 8(2)(b), Roman 1. In his actions on the 5th of July, Commander Nev showed a complete disregard for the laws of armed conflict and the lives of the civilian population in Cerntown. For this, the court must hold him accountable. Unless I can be of further assistance, that concludes my submissions.
Thank you, Agent Hagender. Agent Patton.
Madam President, Your Excellencies, the conflict between Arvent and Sorax wrought devastating consequences for the residents of Cerntown. Dr. Norman Gregory took advantage of the havoc when, following the removal of 4 patients from the Cerntown Hospital, he decided to test a dangerous and experimental treatment on these patients. I will be dealing with the second charge, which is against Dr. Norman Gregory. It is our submission that Dr. Gregory is criminally responsible for the war crime of conducting medical experiments pursuant to Article 25(3)(a) and punishable under Article 8(2)(b), Roman 10 of the Rome Statute. For Dr. Gregory to be criminally liable, there are 6 elements that the prosecution needs to establish. Would Your Excellencies prefer me to outline the 6 elements now?
Well, I think you're going to assume that we're familiar with them. Let us deal perhaps straight with the ones that are in contention between the parties, would you?
Yes, Madam President. I note that if the court is satisfied that all of these elements can be established, then the charge against Dr. Gregory can be confirmed. I will begin with submission 4.1.1, that Dr. Gregory and the critical care team at Mantis conducted the relevant medical experiment in the context of and in association with an international armed conflict. The International Criminal Court in the case of Lubunga held that for this to be established, it must be proved that there are substantial grounds to believe that the alleged crime occurred, was closely related to hostilities. We contend that it was the armed conflict between Sorax and Arvent which created the opportunity for Dr. Gregory and the Mantis critical care team to administer the drug of Silectin to the Arvent patients. We get this first from paragraph 17 of the facts, where it can be seen that the 4 Arvent patients who were injured in the course of the conflict between Arvent and Sorax. Further, the direct consequence of these injuries is that these patients came into the care of Dr. Gregory and Mantis. Further, we contend that Dr. Gregory's conduct was closely related to the hostilities because he conducted the procedures as an integral part of the war effort. Dr. Gregory and Mantis were contracted by a branch of the Sorax military to develop a treatment for fire and smoke injuries, smoke-related injuries. In the course of the conflict between Arvent and Sorax, we know from paragraph 20 of the facts that Sorax military personnel were burned. We contend from this, it can be concluded that Mantis was developing Silectin as an integral part of the war effort to help assist the Sorax military in the conflict. This is consistent with the case of Karl Brandt, which has been raised by counsel for the defence at submission 5.3 under their second count, where experiments were conducted to develop treatments and vaccines which would assist and protect German soldiers during World War II. I will turn now to the second element, where we submit that Dr. Gregory was aware of the armed conflict between Sorax and Arvent. For this to be established, it is only necessary to show that Dr. Gregory was aware that there was a conflict and that this conflict was between the nations of Arvent and Sorax. I note that counsel for the defence has not contended this element on their written submissions. We contend this element has been established because Dr. Gregory was present when the Arvent patients were admitted to the Mantis Clinic after being transported there by Sorax military doctors. I'll turn now to the third element. We submit that the 4 Arvent nationals were under the power of Dr. Gregory, who was acting for an adverse party in the circumstances. The adverse party in an international conflict can be characterised as the enemy state to the persons in question. Due to the fact that the persons in question were Arvent nationals, Sorax can be described as the adverse party in these circumstances. For it,
Could you just elaborate for me a little bit on how then is Norman Gregory defined as part of the adverse party when we understand him to be a CERN resident?
Your Excellency, we contend that Dr. Gregory was acting for Sorax in these circumstances. We get this first from paragraph 21 of the facts, where it can be seen that the Mantis Clinic, of which Dr. Gregory was CEO and chief clinician, had been contracted by a wing of the Sorax military to develop a thermos treatment. We contend this contractual relationship indicates that Dr. Gregory was acting on behalf of Sorax in treating the Arvent patients because he was protecting his financial interests in attempting to advance the treatment as much as he could in line with this contract. We also submit that the Arvent patients were under the power of Sorax because they were in the territory of Sorax at the time the procedure occurred. According to paragraph 18 of the facts, on the 7th of July 2016, the 125th Regiment of Sorax took control of CERN. As the Mantis Clinic was located in CERN, we contend that the patients were in territory which was under the control of Sorax, at the time the procedure occurred.
Yes, Agent, that issue of control under the 4th Geneva Convention, the term is of course occupation, which has a number of indicia that need to be established. And I'm not sure if those indicia are established here. I mean, they may have tactical control of the city. The armed conflict seems to be continuing. Skirmishes still happening under paragraph 18. As a matter of law, can this court conclude that they have sufficient control to be of relevant control for the purpose of your submission?
Your Excellency, we accept that there is not enough evidence on the facts to indicate that Sorax had control of the entirety of CERN. However, we contend that on the evidence, it is stated that Sorax had control of CERN town, of the city centre of CERN town specifically, and we contend this should be interpreted as them having de facto control over the city centre.
Is it relevant then if this court came to a conclusion that it did not find that there was sufficient indicia of control or occupation, but still could find that Dr. Gregory had sufficient control over the patients? Would that be sufficient?
Yes, Your Excellency, we submit that would be sufficient.
And on that basis then, it all then turns on that relationship between Dr. Gregory and Sorax, and you're submitting that the contract is enough to characterise this as being in the hands of an adverse party. But if that's the case, I mean, Dr. Gregory was not beyond the contract, was not accountable to the government of Sorax, was he? He wasn't responsive to their directions or orders outside of that contractual relationship.
Yes, Your Excellency, we do acknowledge that. Our contention is that Dr. Gregory was acting in the interests of Sorax in fulfilling his contractual obligations in these circumstances, and therefore it can be found that he was acting on behalf of the adverse party.
You're saying the contract is enough to satisfy that requirement?
We contend in these circumstances it is.
And is there any weight you can put on the fact that the leader of the United CERN Independent Party had been elected the chief administrator, that 60% of the population of CERN time was of Sorex origin, and that would appear that there was a certain willingness. Certainly the administrator had looked to Sorex for support. Does any of that give a flavour to the environment that we're here discussing?
Yes, Your Excellency, we contend this assists in establishing that Dr. Gregory and Sorax were more likely in the circumstances to have an allegiance to Sorax as a nation as opposed to Arvent in these circumstances.
Thank you.
I will now turn to the fourth element, where we submit that administering the Solectin to the 4 Arvent nationals constituted a medical experiment. Your Excellencies, I note that medical experiment is not defined in the Rome Statute, nor in related conventions. However, we contend that case law arising out of post-World War II trials.
That effective
Not
contribution.
necessarily. I mean, there is some evidence that this afforded a particular line of fire. It had a particular military utility, but it's your submission. I leave it to you.
Your Excellency, the situation is analogous to a sniper's nest, and a sniper does not actually have to fire from this nest in order for the threat of the sniper to make that effective contribution to military action by preventing Soraxian forces from...
No, I accept that. As the second element of the test. The first test is nature, purpose, use, or location, and I guess I'm trying to clarify in my mind if we're talking about potential uses, we're not in uses anymore. We're in another category, aren't we?
Your Excellency, our submission is that the Arvantian combatants were still in the building and remained in the building at all present times until the attack.
Okay.
Agent Webster, Sorex had a drone. They put it up before. They didn't put it up again to check, did they, before they made the attack?
They did not, Your Excellency, but it is not clear on the facts whether his drone capability was in fact under Commander Nev's jurisdiction. He was the commander of the 125th Regiment, and the forces responsible for him were the artillery close fire support, which conducted the attack, which gave rise to these charges. Your Excellencies, we submit that in circumstances in which the final artillery attack was ordered, Commander Nev indicated that there was some urgency to his order. It is critical that we push forward through CERN Town to reach our naval base. He ordered, and do not delay. Your Excellency, it is our submission that Commander Nev and his forces had to use their discretion and the resources available to them to make their attack, and as we will further go on to submit, in taking the appropriate precautions in attack to minimise damage to the civilian population.
Do you refer to that to the message suggesting that civilians leave in an hour and a half in an area where the roads had been badly bombed and it was difficult for vehicles to move? Is that the precaution you're speaking about, or some other precaution?
Firstly, Your Excellency, the prosecution has attempted to submit that through an absence of precautions taken, the perpetrators can be inferred to have the mental element, as in their submission, the civilian population clearly was not respected. However, we refer to 2 chief precautions being taken. Firstly, the verification of the target, which was feasible and adequate in the circumstances as we have submitted, and secondly, that effective advance warning of the attack was given. The exact incidence of the obligation under Article 57, paragraph 2C of Additional Protocol 1 to give effective advance warning were explored by the United Nations Human Rights Council's fact-finding mission Special Rapporteurs into the conflict in Gaza in 2014. 2 specific incidents of this obligation were referred to. Firstly, giving civilians sufficient time to evacuate upon warning of attack. Your Excellencies, it is our submission that in the circumstances, 90 minutes was sufficient. As we have submitted, there was some urgency and criticality in the situation giving rise to Commander Nev's order. Furthermore, the operation conducted by cyber forces of Sorax in hacking the telecommunications network on Surtown and sending out this text message would have taken a great deal of time. Furthermore, the warning was sent out, and unlike further warnings referred to in the fact-finding report to the UN Human Rights Council, sufficient indication was given as to the time which the attack would occur and the exact location the attack would occur, and this is the second incident of the obligation to give effective advance warning that we submit was met in these circumstances. That is, that civilians were indicated in the warning, given indication in the warning as to what they had to do in order to be safe from an artillery attack. That is, evacuate the city centre. Therefore, the effective advance warning in this case can clearly be distinguished from what the Special Rapporteur said was not effective advance warning given by Israeli Defence Forces in their offensive against Gaza. That is merely giving general warnings, not indicating the time and the place generally that attacks were to occur. Your Excellency.
Agent Westbury, I note that it says civilians should leave the city centre and that this message went to all mobile phones in proximity to the city centre. Doesn't that then speak to an intention to attack generally and not with a specific target?
Not necessarily, Your Excellency, as we submit that this warning given to identifying the city centre as the target to be attacked was sufficiently pinpointed to warn the civilian population who could be affected by the attack without alerting the Arbantian combatants who were the object of attack of the impending attack, and hence taking away both the military advantage of supplies in the attack, allowing them to evacuate the building, and this would also render that building no longer a military objective for the purposes of Article 52, Paragraph 2 of Additional Protocol 1. Your Excellencies, returning to our submission that civilians were not the object of attack, we submit that unlike what was submitted by our learned friends, the attack was not indiscriminate. Paragraph 4 of Article 51 defines 4 ways in which attacks can be indiscriminate. They can be indiscriminate if they are not directed at military objects, and as we have submitted, this attack was. The target, the office building, was the only building in the city centre destroyed in the attack. Furthermore, Your Excellencies, the shells fired were not analogous to firebombs, incendiary bombs, or the barrel bombs used by civilian forces, but the effects of them could be limited. Your Excellency, the final subparagraph of paragraph 4 of Article 51 refers to the means and methods being used in attack not being able to be sufficiently directed against civilians in order for them to be defined as indiscriminate. We submit that neither by their method or their means of attack, these artillery shells were indiscriminate. Shells are not inherently indiscriminate, Your Excellencies, and as demonstrated by the previous artillery attack referred to at paragraph 13 of the facts, they could be directed at military objects without causing any collateral damage to the surrounding civilian population. Furthermore, as referred to in the case of Prosecutor and Gottadina, while there can be an error rate in shells inherent in characteristics due to the weather, this does not render them an indiscriminate method or means of combat. Your Excellencies, while the prosecution submitted that the attack should have been suspended once it was clear in their submission that these factors made this artillery more inaccurate than it was on the previous occasion, our submission is that there was simply no way for the attackers to know that this would be the case until the artillery was in fact launched. Your Excellencies, the second element which we say is not satisfied is that the perpetrators intended the object of their attack to be the civilian population.
Before you proceed to that submission, the concept of proportionality, of course, is contained within Article 57, which talks about precautions. And the Moot case does draw indirectly, I guess, an analysis that if an attack is disproportionate, then it might be characterised as being indiscriminate.
within the shoes of the military decision maker at the time the attack was launched, this attack was not disproportionate. It was not known what the effects of the artillery fire upon the office building and the adjacent hospital would be at the time that the attack was launched. And it is our submission that the fire started by one of the shells, which is what caused the loss to civilian life, is not something that could have been sufficiently foreseen to factor into a proportionality assessment. But in any event, Your Excellencies, Commander Neff has been charged under Article 82B1 of the statute. And in the trial judgment in Katanga, the trial chamber referred to the clear need to delineate this offence from the crime contained in Article 82B4 of the statute. It needs to be proven in our submission to the standard of concrete intent, something which at law is accepted by the prosecution at paragraph 2.5.1 of their written submissions, that the perpetrators intended the principal object of their attack to be the civilian population. The result of incidental civilian casualties, while unfortunate, is not in our submission sufficient to meet this test. Your Excellencies, we submit that if this pre-trial chamber disagrees with the position we have taken and finds that in fact a crime has occurred within the meaning of Article 82B1, we still submit that Commander Neff cannot be held criminally responsible for this attack, as he could not have foreseen that the crime would have occurred in the ordinary course of events. Your Excellencies, this element is required under the mode of liability in Article 25(3)(b), under Article 30, paragraph 2 of the Rome Statute, as was accepted by our learned friends. In the confirmation of charges decision against Benbar, the pre-trial chamber interpreted the phrase will occur in the ordinary course of events in Article 32 as meaning a practical certainty that the consequences referred to would occur. The facts do not offer concrete and tangible proof that Commander Neff had this awareness of a practical certainty that these consequences would occur.
Agent Westbury, are you convinced that Commander Neff was unaware of the images from the Sorax drones which show the damage to the buildings next to the roads? I don't know what the physical distances were, but wouldn't that indicate an understanding of the consequences of the artillery attack?
Your Excellency, it is our submission that this damage to the surrounding buildings from the earlier attack is more consistent with fragmentary or shrapnel damage from the impacts of shells rather than the impacts of shells themselves. And while it is damage to the buildings, it is not of a sufficiently high level or impact of damage to indicate that the civilian population would be threatened significantly by the use of these shells. In fact, the fact that there was no civilian casualties from that earlier attack supports that submission that we make. Your Excellencies, the authority referred to by our learned friends, the confirmation of charges decision in Moot can be distinguished from this situation, as Moot was actually informed of crimes committed by his subordinates and still continued to give orders in the form in which he gave them. The current case can be distinguished, the case before the International Criminal Tribunal for the former Yugoslavia, Prosecutor in Strugar, is illustrative in this regard of our submission. In that case, despite Commander Strugar having knowledge, in the words of the trial chamber, of a real and more than ordinary risk that crime would occur, this was still not sufficient for him to have knowledge of a substantial likelihood that a crime would occur. Therefore, Your Excellencies, this standard is not even made out on this facts. As demonstrated by the previous artillery attack, Commander Neff had no reason to believe that these operations conducted by his troops would be conducted in anything other than in accordance with the laws and customs of war. Your Excellencies, the impact of the shells on the hospital and the resulting loss of civilian life were tragic, but they were accidental, and Commander Neff is not criminally responsible for these accidental consequences. If Your Excellencies have no further questions, that concludes my submissions.
Thank you, Agent Westbury. Agent Gillian.
Your Excellencies, Madam President, today I will be making 3 submissions for the defence as regards the second charge against Dr. Norman Gregory. Firstly, that the accused did not commit each of the 6 material elements of the war crime of subjecting persons to medical or scientific experiments under Article 8, subsection 2b10 of the Rome Statute. Secondly, that he did not commit these elements with the requisite intent or knowledge. And finally, that he is not criminally liable for committing that offence through other persons under Article 25, subsection 3a of the statute. I will devote the majority of my time to my first submission. Your Excellencies, the accused in this case was faced with gravely ill patients and chose the only course of treatment possible to save their lives. That treatment was given with the utmost care for those patients and for the benefit of those patients' health, and not to further the SORAC's military effort. The accused gave these patients a chance to live. Turning to the first part of my first submission, which I note will be in 3 parts. Our learned friends have stated that the administration of Selectin to 4 Arvant patients was a medical experiment that was not justified. While we accept that the Selectin treatment was experimental in its nature, we submit that it was not an unlawful medical experiment under the test of Article 8 because it was justified in the circumstances according to both their health and the general standards accepted by SORACs. On this point, Your Excellencies, we refer to the elements of crimes of the Rome Statute, which at page 23 provides that a treatment, regardless of whether or not it is experimental, will be justified, provided it is firstly indicated by the health of the patients, and secondly, if it is consistent with the generally accepted standards, which would be applied in similar circumstances to the nationals of the state providing that procedure. As to the first point there, we contend against our learned friends that this treatment was indicated by the health of the patients. Firstly, Your Excellencies, at paragraph 20 of the facts, it is stated that these patients were barely responsive at the time that they arrived at the Mantis Clinic. Secondly, Your Excellencies, they were in such a dire physical state that they had to be placed in medically induced comas and put upon mechanically assisted ventilation. They were kept in this state for 2 days between the 8th of July and the 10th of July. While our learned friends submit that this is a reason to show that the Selectin treatment was not justified, given that they had remained in that state for 2 days and that 2 patients had been stabilised, we submit in the contrary that for patients in such a dire state, where they are essentially being assisted in their breathing, that they are in such a dire physical state, 2 days is an incredibly long time for their health. And despite the fact that 2 of the Arvant patients had stabilised in their medical coma, they were still in an extreme situation of health, given that they did need to be maintained on mechanically assisted ventilation.
Agent Blair, what weight should we put on the reservations of the treating doctor? That would seem to be the medical person with the closest contact with the patients and best placed to make a judgment.
He was the treating doctor, Madam President. However, the accused was the first physician to see these patients and had on the facts taken an active role in overseeing their treatment. We submit that the disagreement that the senior doctor had with the accused as to the necessity of Selectin was simply a disagreement amongst professionals, amongst colleagues, and that the decision to administer Selectin made by the accused and passed down to the senior doctor, who then later agreed upon careful consideration, indicates that their state, having remained in an extreme health situation for 2 days, did require more than the conventional treatment that had been administered to them in that time.
How relevant is it that in that unstable condition that you've emphasised, Dr. Gregory was very keen to administer the new Selectin treatment at that very early stage?
While our learned friends have submitted that the accused was simply an agent for SORACs, acting under an ambition to develop this experimental drug without any consideration for the patient's best health interests, we submit we submit that his approach to administering Selectin and the fact that he was urging the senior doctor to take this approach indicates that he was complying with the general standards expected of physicians noted in the preamble of the World Medical Association's Helsinki Declaration that physicians first give regard to the best interests of their patients. He noted in his professional opinion, as stated at paragraph 24 of the facts, that these patients had remained in an extreme health condition and that given there were no significant changes to their health and no foreseeable changes to their health under the application of conventional medicine, that some experimental treatment was required and that Selectin was the best treatment at hand to render their situation an improvement.
There might be a different judgment to be made if someone's on the verge of death, but at least 2 of these patients were stable and the treating doctor thought it too early. Why not delay in the circumstances, at least for those 2 patients?
With respect, Madam President, while they were stable in that condition, they were still in such a severe state of health that they had to be mechanically assisted in their breathing. And for patients in such a situation, their condition could turn at any moment. While it had not done so in that 2-day period, 2 of the Ardent patients did remain in the same condition that they were in upon arriving at Mantis. And at paragraph 17 of the facts, it is noted that the injuries they received in the hospital bombing were life-threatening. They were, in fact, in a situation where their lives were in danger. Your Excellencies, if I may...
So just make that clear, are you suggesting that the 2 patients that we're told were in a stable condition were in fact not in a stable condition? I mean, the idea of being in a stable condition, as I understand it, is that your life is not immediately under threat.
Madam President, they were in a stable condition in the circumstances, in the context of still remaining in a medically induced coma and still remaining on mechanically assisted ventilation. They were stable according to the standards for critically endangered patients in a critical care unit. This does not mean that they were in a comfortable health position, particularly given that they had to remain unconscious.
Yeah, but it might be a good reason to wait a while, mightn't it?
While that was a consideration made by the senior doctor, the accused, a chief clinician of an international private company with presumably considerable medical experience behind him.
A certain degree of conflict of interest, I'm sure you agree.
There were other interests involved given the contract between Mantis and Sorax. However, as noted, this physician was pressing for the treatment in line with his utmost duty to the patients at hand. Turning to the second point of the elements of crimes, Your Excellencies, this treatment was consistent with the generally accepted standards of Sorax, as Sorax had agreed to limited testing on those patients and in fact had obtained the consent of Sorax naval personnel in undertaking that treatment. And in this situation, clearly Sorax had applied the same standards to their own personnel, given the 2 Sorax Navy personnel who were treated with Selectin, at the same time as the Ardent patients were treated. Our learned friends have submitted that the lack of consent by the Ardent patients compared with the consent that was provided by the Sorax Navy personnel should cast an egregious shadow over the Selectin treatment that was administered to the patients. However, we submit firstly that consent was not practically possible in the circumstances, given the unconscious state of those victims. And secondly, that given that there was an armed conflict continuing, it was impractical to obtain consent from legal representatives of those patients. Further, Your Excellencies, I would point you to the extreme nature of the circumstances and the fact that this treatment had to be considered immediately. Further, our learned friends neglected to note that consent is not an end in itself, but rather a means to ensure that the best interests of the patients are provided for. We submit, given that the same treatment was applied to Sorax personnel as to Ardent patients, and that those Sorax personnel had consented, that the best interests of the patients were considered, given that their injuries were, for all intents and purposes on the facts, the same as those personnel. There is no reason on the facts that is known or likely why these patients would have rejected the offer of selective treatment. Your Excellencies, I will turn to the second part of my first submission. That is that the other patients were not in the power of an adverse party at the time they received the treatment. Our learned friends referred to the law of occupation, which goes to the test provided by the commentary to Article 11 of Additional Protocol 1. That is, that those who find themselves in the territory occupied by a party to a conflict are automatically under the power of an adverse party. We submit that under the correct test for the occupation of a territory, provided through the effective control test under Article 42 of the Hague Regulations of 1907, that the SORAC's 125th Regiment did not have occupation of Cerntown at the time that the patients were treated. This test requires, firstly, that there be forces on the ground, secondly, that those foreign forces exercise public authority that is akin to a governmental function, and finally, that there is a lack of consent from the local government in the territory. While we acknowledge that the 125th Regiment at paragraph 18 of the facts did have a presence in Cerntown at the time of the treatment, they did not exercise public authority akin to anything like a governmental function. Rather, Your Excellencies, they were in Cerntown for a very limited purpose, that is, to allow the SORAC's forces to continue on to their naval base. Furthermore, Your Excellencies, as noted at paragraph 4 and paragraph 8 of the facts particularly, the CERN local government and CERN residents had in fact consented to SORAC's presence and were amenable to SORAC's remaining in the region.
There may be force in that submission regarding the indicia of occupation, but Article 4 of the 4th Geneva Convention does talk about those who find themselves in any given moment, in any manner whatsoever, in the hands of a party to the conflict. And case law, as I read it, does make a distinction between control of a territory on the one hand and actual personal custody of an individual. And in that second context, Article 4 would have application. When you're in the physical control of somebody, you are in effect in the hands of an adverse party for the purposes of certainly the law of armed conflict. To that end, I'm not persuaded that your argument on territory is fine. I think it has merit, but I think there's another test that is equally applicable here. What's your response to that?
Certainly, Your Excellency, and we note that our learned friends did state that as the patients were in Mantis and Mantis had a relationship with SORAC, that constituted an adverse party relationship between SORAC, Mantis and the patients. However, we would direct Your Excellencies to the ICTY Chamber's decision in Tardich, where at paragraph 96, Tardich provided the test for allegiance which must be made out to show that a party is adverse. This test has been accepted by this court in the confirmation of charges decision in the case of Lubanga, and provides that rather than nationality be the test for allegiance or for a party being an adverse party, but the test should be that of substantive allegiance to a party to a conflict. We submit that Mantis did not have any substantive allegiance to SORAC through their contract. Rather, this was simply a commercial contract that regarded a very discrete part of their function as a medical clinic. Simply a contract regarding the development of one drug. This is by no means sufficient to satisfy the Tardich test of substantive allegiance. Mantis cannot be seen to have had allegiance to SORAC as a clinic overall. Rather, the relationship between Mantis and SORAC should be considered that of a provider and a client as to one very discrete purpose.
Agent, I accept that submission, but the facts state in Article 26 that the surviving army patients were taken to the medical facilities on the SORAC's naval base for further rehabilitation. I mean, there's that connection, isn't there, between the military, the SORAC's military, and therefore the government, and Mantis and Dr. Gregory. Is that not something the court can take notice of?
Perhaps, Your Excellency. However, the fact that SORAC began the treatment of these patients in their medical facility at paragraph 8 of the facts, and that they then transferred them to Mantis, the independent clinic, SORAC had been overseeing the treatment of these patients. and in fact was not adverse to them in regards to their actual situation, noting particularly that Storax and the CERN residents had a friendly relationship, and that Miss Atwood of CERN had acknowledged that Storax was the friend of the CERN residents. Your Excellencies, I will turn to the third and final part of my first submission. That is that the selectin treatment did not have a sufficient nexus to the international armed conflict between Storax and Arband, because it was not associated with that conflict. Our learned friends...
Sorry to interrupt, but hadn't the Storax Field Hospital actually delivered those patients to Mantis? Wouldn't that indicate that there was a nexus? There had been, in fact, damage in artillery fire as part of that conflict?
We acknowledge that Storax had initially transferred the patients to Mantis. However, this test regards the allegedly criminal conduct itself, that is, the administration of selectin by the accused to the patients while at Mantis. Thus, the fact that Storax had initially transferred them to Mantis has no material weight on the nexus test at hand. Your Excellencies, that test was referred to in the case of Lubanga, as our learned friends noted. However, Lubanga referred directly to the case of Kirinach, which initially laid out that test at paragraph 58. That is that at a minimum, the armed conflict must have played a substantial part in the accused's ability to commit the conduct, their decision to commit it, and the purpose for which it was committed. We submit that the purpose for the selectin treatment was primarily for a therapeutic purpose, and thus not to further the Storax military effort. Even if that experiment were to be seen as solely or primarily for the purpose of furthering Storax's military effort, there is no conceivable practical way in which it could do so, given the extensive rehabilitation time that is required for severe burns patients who would be receiving selectin. That is, any Storax Navy military personnel who would receive that treatment must then go through months of rehabilitation before they could then contribute back to a Storax military effort. Thus, the fact that this treatment may provide some benefit in some form to Storax military personnel further into the future, there is no way that it could directly provide a military advantage to Storax in the circumstances at hand to this armed conflict. Your Excellencies, I will turn briefly to my second submission, and that is that the accused did not commit these material elements of the crime with the requisite intent and knowledge. Our learned friends have provided the test from the case of Lubanga, provided at paragraph 323. That is, that the accused must have had concrete intent, and this, as interpreted by Lubanga, is equivalent to a cognitive awareness that there is virtual certainty that their conduct will result in the circumstances, in the consequences that it did. Here, Your Excellencies, the accused is noted to have believed selectin would have a significantly less harmful effect on patients as it had in mice, and thus he cannot have had virtual certainty that such harm would result to those patients. Furthermore, under that test, Your Excellencies, it requires that the accused in fact intends those consequences to occur. We submit there is no conceivable form or interpretation of these facts that would lead to the suggestion that the accused could deliberately intend that harm should come to those Arband patients. Firstly, as we have submitted, he was treating them for the benefit of their health. But secondly, even if he, Your Excellencies, I note my time has expired. Might I request an extension of time?
How long? Yet again?
1 minute, please.
Yes, you may have that extension.
Thank you, Madam President. Even if he were conducting these experiments for the purpose of the experiment itself and not for the benefit of those patients, we submit that there is no way he could have intended a negative outcome to those experiments, given that his interest would be in furthering the development of the treatment and fulfilling his contract with Storax. I leave my arguments as to the mode of liability as read on my written submissions, Your Excellencies. May I please?
Thank you, Madam. We'll now hear the rebuttal from prosecution.
note that no clarification in the Rome Statute or relevant conventions has been provided clarifying what serious endangerment requires. We acknowledge that serious endangerment could refer to the likelihood of a consequence occurring. However, we contend in this context, it could also refer to the likely magnitude of the consequence. Dr. Gregory observed in clinical trials of Silectin that the drug caused serious blood clotting in 15% of mice. Your Excellencies, serious blood clotting presents a range of extremely devastating consequences for a human's health. For example, it causes multi-organ failure. In light of this, we contend that Dr. Gregory was virtually certain that he was seriously endangering the health of the ardent patients because he was aware of the potential magnitude that the drug could have on the patient's health. Thank you, Your Excellencies. That concludes submissions for the prosecution.
Thank you. We'll now take some rebuttal from the defence.
Your Excellencies, the test provided by our learned friends as to the mens rea element has also been adopted in our submissions from the case of the Bunga, which did provide that a practical certainty must be made out to satisfy the intent required under Article 30 of the Rome Statute. This is a standard of virtual certainty or practical certainty, or at the very least, a high possibility. This is impossible to make out when dealing with an experimental treatment such as Silectin. While the accused had noted the risks attendant to the mice in the stage of developing the drug, he also believed that there was a greater than 60% chance that this drug would drastically improve the situation of the patients. It cannot be said that he knew to a standard of virtual certainty that the drug would result in their deaths or would result in more significant consequences to the human patients than the mice test subjects. He had believed, on the basis of scientific evidence, that the drug would in fact have less significant consequences to human health than the mice's health. Thus, the standard of virtual certainty can by no means be made out. And given that the requisite cognitive element of virtual certainty cannot be made out, it cannot likewise be said that the accused in this case desired or consented to the outcomes that did occur according to the volitional element required under Article 30 as interpreted by the Chamber in the case of the Bunga. May I please?
Thank you. The Court thanks all agents for their submissions today, and we will temporarily adjourn.
All stand. That concludes the grand final for the moment. The judges will now deliberate and they'll come back with feedback and we'll have the closing address. Thank you.
Oh, hey, how you doing? Good, how are you? Well.
Yeah, it died.
Oh no.
Okay. Okay, so as I think you know, you don't learn right now what we thought about you in terms of precise marks, but I'd just like to say for the three of us that we thought you were all excellent. Mooters who really enjoyed the presentations. I can say from my deep experience, I've seen young counsel at the bar who've not performed in, I thought, with the competence and skill that you displayed today. So really well done to all of you. It was a great performance and a credit to you all. I know how nerve-wracking it is, but you all did that, I thought, well and addressed the court confidently and in a quite engaging manner. Of course, you might go on to do this sort of thing again, either as mooters or as young advocates in the courts. We thought we might just give you one key message, and I think that message is probably not surprising coming principally from me, but not only from me, is that facts are critical. Even in mooting, facts are critical. It's very easy to think that the law is what cases turn on, but in fact, it's rare in practice and it's rare in moots for the law to be decisive. If the law was going to be decisive, the moot wouldn't have been set. It's been set because it can go either way on the law. And so very often what